Hello YouTube, I'm Vince White. I'm an employment attorney and we are answering publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. Yeah, I know. It's a simple concept. This is not supposed to be like a high volume channel. We're not trying to get views. We're trying to answer questions. We're trying to help people, all right? So I get it. You can make your comments. I know. Not a big channel. It's okay. It's about helping somebody, not whatever. Anyways. All right, we got a question from YouTube user Jonte Woodbury, posted about a month ago. Sorry for the response time. And it was posted on our video from way back in August 31st of 2022, entitled, "How long does an EEOC investigation typically last?" And Jonte asked, during the EEOC process, do defense attorneys commonly refuse settlement negotiations, stating they believe the case is a summary judgment case as a defense tactic, even if it's obvious the complainant really has sufficient evidence and valid claims? Under what instances would counsel for the agency refuse negotiations? So I assume when you say counsel for the agency, you mean counsel for the employer? Are refusals ever used as a control tactic? Will defense attorneys refuse to negotiate even though the plaintiff has a solid case? Okay, so we may not know enough to fully answer this question, and I'll say why. I don't know what you're demanding. I don't know if you made a demand. I don't know like what the story is, but if you're demanding a huge sum of money that is much larger than defense counsel thinks they will lose, it is possible that they would just be like, this guy's wasting my time. I'm not going to counter, right? The other thing that's going on here is you're saying it's obvious you have sufficient evidence and valid claims. I believe you. But a lot of people who call me up and tell me that it's obvious they have sufficient evidence and valid claims don't. I believe you. I believe that you have sufficient evidence and valid claims. But I'll say that 70% of the people who call me up and say, bro, I got the case for you. It's like, you don't. You don't even have a case. You don't even know what discrimination is. And this is not you. I'm not talking to you. I'm just saying in general. So like, it's hard for me to judge what's going on here. Generally, if defense counsel sees a claim that they actually fear, they will put money on the table. It's just a smart thing to do. It sounds like you're unrepresented here. Sounds like you don't have an attorney. So that could be part of it, right? I mean, they may not fear you because you don't have counsel. That happens. That's a reality. They may not want to negotiate with you because they think you're being aggressive, or they don't think it's going to go anywhere, or they think you're asking for too much. Those are all possibilities. And your actual question is like, could that be a tactic? Yeah, it could definitely be a tactic, but it's not a very good tactic. And I'll tell you why. So like, if you come to them, you're like, I want $100,000. Not saying you did, just hypothetical. And their response is, no, but I'll give you $2,000. Well, there's a chance that you'll counter, and there'll be a conversation, and they could end up settling that case for less than $10,000, right? That is often a defense attorney tactic. If you, by contrast, make that demand for $100,000, and they come back with not a penny, not ever, we're going to beat you on summary judgment. Well, there's not a lot of conversation left to be had. They shut down the conversation, which means they're kind of guaranteeing the case doesn't settle, which means it actually will go to summary judgment. So, listen, do I think some defense counsel might try to be tough like that? Yeah. I mean, I can think of defense counsel who do ridiculous things, right? Like, I don't want to name the firm. There's this fellow Weber who will get on the phone and just start misquoting the law to defense to plaintiff's attorneys, right? Like you don't have a claim. That's not how retaliation works. And it's like, dude, you got a couple of clients, you got a partnership in a big law firm, but we all know, like he knows that he's just lying about the law. He knows I hope he knows, he's a fantastic moron, like a beautiful idiot, or he's just trying to be a tough guy on the phone, right? And it's funny because then competent attorneys come in, associates come in and take the case away from him because, he's more the guy who originates these cases for his firm, not really the guy who litigates them. And then competent attorneys be like, hey, yeah, I know what Webby said, but how's a couple $100,000? Right? So, listen, there are those attorneys, but they're like a special kind of stupid, and there aren't as many stupid defense attorneys as you would think. I'll be honest. There's a lot more. There's many, 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 many more stupid plaintiffs attorneys than there are stupid defense attorneys. Because defense attorneys get paid really, really good. Right? Huge, guaranteed money most of the time. So there tends to be a flight to quality, right? There's a lot of competition for those gigs. Plaintiffs' firms, people can survive on, 2-3 cases a year if they get a decent result. So, people do. I know, certainly I can think of people that I don't know how they get dressed in the morning who make a living as a plaintiff side employment attorney, right? So, yeah, listen, there are certainly stupid defense attorneys who might engage in this tactic. But I think running the probabilities, that's probably not the answer here. There's probably something else going on. And you may want to look at what else is going on. Are you engaging in behaviors that are shutting down negotiations? Is there a flaw in your case? Is it because you don't have an attorney, right? Look at what's going on. You're going to have to dig a little deeper into this. It's probably not so simple as this defense attorney is dumb and trying to be a tough man or woman, right? It could be, right? I'm not over here knowing everything about your situation. I certainly don't know anything besides what you provided here. I'm just saying, my guess is there's more to it than just a tactic. Jonte, that's a cool name. And I hope that this was helpful. If it wasn't, or if you have follow-up questions, I will indeed track the comments on this video, and I'll try to give you follow-up answers. I'm sorry I took a month to answer your question. The channel has been a little bit wild lately. It's really grown and getting behind. If this was helpful, like and subscribe. It helps me to help more people just like you, and I hope you get paid. Really, truly. Take care.